some of the land rights tensions in Talamanca. However, because of complicated constitutional issues and increased severity in environmental laws, living inside Regama today represents yet another debilitating restriction on the Talamancan people and their land. In July 1985, around the time that roads and electricity made the Talamancan region more visible and accessible, an act of Congress created the Gandoca Manzanillo Wildlife Refuge, Regama. The goal of the refuge was to implement a cohesive plan for development of both public and private lands along the Talamancan coast, reaching biodiversity protection goals while allowing for the continued harmonious participation of the people who lived within its boundaries. The refuge is mixed in the sense that some of the land is privately owned, some of it publicly owned, and much of it inhabited by people without clear title to the land. The refuge is huge, approximately 23,349 acres. It's important at this point to understand that Regama overlaps with land restricted by the Maritime Zoning Law, the ZMT, a regulation that heavily restricts development along the coast where many Talamancans live. My colleague will discuss more about this in a moment. The status of the land subject to both restrictions is complicated to say the least. Suffice it to say that Regama and ZMT together create massively complicated barriers to the use, improvement, and enjoyment of land subjected to their restrictions, having a dramatic effect on the livelihoods and liberties of the Talamancan people. One of Regama's central goals was to have a cooperative management program. People would not just be subject to government regulation. The people themselves participated in the planning, zoning, conservation, and development of their land. The management plan of Regama was governed by various agencies of the government, but what made Regama so unique was that it also involved both the Talamancan municipality and organized local residents. This collaborative and inclusive management format, at least on its face, appeared to give Talamancans more autonomy in both planning and usage of their land, and was successful for several years. Then things began to change. In 2004, governmental agencies suspended the management plan by alleging an improper approval process. In effect, many people still don't know the full truth about why Regama's management plan was suspended, leaving the facilitation of the refuge in flux. As a direct result of the suspension, the process of issuing land use permits within the refuge to allow people to put their land to certain uses became completely frustrating. In 2008, after much political back and forth, the management plan was reapproved, and this was thought to be a major victory for the Talamancan people within its borders. However, along with this reauthorization came a shift in the type of biodiversity law applicable to mixed refuges, including Regama. This shift has had devastating impacts on the Talamancan people. From the more lenient wildlife law, the people now had to live under the far more restrictive forestry law regime. Now future use permits can only be issued in accordance with this much stricter law, and even many previously issued permits were revoked. Now the Talamancans living within the refuge could not easily, if at all, build on their land, improve their land, or utilize their land. Nor could they even repair or reinforce existing structures like their driveways or the foundations of their home without obtaining approval of the managing authority and environmental impact reports. The shift in laws left the people in a paralyzed state in which they could not improve their lives or their land for the better. Not only that, but there were now strict penalties in place for violating the restrictions, including eviction from the land, criminal sanctions, and imprisonment. The idyllic and harmonious Regama had become a source of oppression, insecurity, confusion, and economic stagnation. To the outside world, however, it still appeared to be a paradise of biodiversity. Further complicating matters is the confusion over the exact boundaries of Regama. Originally, specific urban areas like Puerto Viejo, Gandoca, and Manzanillo, where many Talamancans live, were not considered part of the refuge. In 1994, a legislative decree changed this, and suddenly these cities and their residents came within Regama's boundaries, subject to its restrictions. In 2000, another decree placed them back outside the refuge. In 2005, yet again, they were placed back inside Regama. Clearly, this flip-flopping led to extreme insecurity and confusion for the residents of Talamanca. Were they or were they not subject to the restrictions? In 2012, a legislative attempt to reduce the size of the refuge was struck down as unconstitutional. Though the reasoning isn't clear-cut, the reduction of the size of a refuge once established may violate the provision of the Costa Rican Constitution that gives its citizens a right to a healthy and ecologically balanced environment. Ironically, a constitutional provision designed to protect the rights of people who successfully used to violate them. Proposed legislation regarding Regama's boundaries remains active to this date, and the future of the refuge, and more importantly, of the Talamancans within its borders, remains unknown and insecure. I will now turn things over to my colleague Jonathan Culpepper, who will be explaining more about the maritime zoning law and its huge impact on the Talamancan people.
I will now speak about the drastic effects of the maritime zoning law is having on the residents of the Talamancan Coast. The topics I will speak about regarding the maritime zoning law include its history and intent, the problem and effect on the Talamancan Coast, the players combating the issue, and the current state of the problem. The maritime zoning law was passed in 1977. Its jurisdiction defines the areas within 50 meters of the shore as public domain, where no structures can be built. The next 150 meters are considered restricted areas, in which buildings can be legally built through a concession system administered by the municipal governments. The law aims to protect Costa Rica's beaches from overdevelopment and environmental degradation. The initial purpose of the maritime zoning law was basically done in the context of preserving the beaches and protection from large economic interests. The idea when it was created in 1977 was to regulate the area so that there would be public access to the beaches and to the Talamancan coast. Also, the goal was not to allow big tracts of coastal property to be privatized. As previously mentioned, the first 50 meters are completely public, and for the next 150 meters, the idea was to have additional planning to have access to the coast. But also, to give the municipalities very valuable land, basically rent out the property for concessions. Recently, however, the Comptroller General of the Republic ordered the demolition of properties found within the restricted zone in regions across the country. In 2003, the Comptroller General's office ordered municipalities to enforce the law. The Comptroller General's office gave the municipality of Talamanca deadlines to provide documentation to show that plans to destroy the properties are underway. Owners of businesses and residents of the Talamanca coast feel as though they should be exempt from the demolition because they bought the land before the maritime zoning law was enacted in 1977. Puerto Viejo was recognized as a city in 1935 by Costa Rica's Constitutional Congress as part of the Talamanca coast. However, since the passing of the maritime zoning law in 1977, recognition of Puerto Viejo, which would entitle the Talamanca municipality to manage concessions in the maritime zone, has not been acknowledged. Therefore, the maritime zone law, as it has been interpreted, has voided any land rights for people in Puerto Viejo due to the fact that the city falls almost completely within the maritime zone. One of the major players fighting this problem includes Edwin Patterson. He is a fifth-generation Puerto Viejo resident and former lawmaker. The new change in zoning laws enticed Patterson to present a bill in 2003 called Patterson's Bill. That bill would issue title to landowners inside the maritime zone who could prove that they had been on the land before the 1977 law was enacted. Also, this bill was originally passed by the Legislative Assembly. It was annulled in 2005 by the Constitutional Chamber of the Supreme Court. Currently, there's a 2-year moratorium in place which halts the pending evictions and demolitions of property within the maritime zone. During this time, lawmakers have been working to implement a legal solution to avoid the evictions and demolitions set to take place at the expiration of the moratorium in September 2014. These legal solutions have predominantly taken the form of proposed bills aimed to redefine the boundaries of the coastal communities. One of the proposed bills, known as the Law of Existing Constructions, was designed to regulate existing buildings within the maritime zone and give the local municipality the exclusive right to offer the people of Talamanca permission to use the land. This bill's success is contingent upon the municipality creating a regulatory zoning plan. This bill is currently in the process of passing the Legislative Assembly so that it can provide a temporary solution to land rights issue facing the people living within the restricted area of the maritime zone. This includes a portion of our presentation concerning the maritime zoning law and the current state of the problem.
Good afternoon, I'm Jackie Grace, and I'm Judy Piott reporting live from the LO10 News Desk. We have some legal news regarding the residents of Talamanca. We'll go live to our legal reporter, Molly Manson, who was right outside of the courthouse as the bill came down. And the Coastal Urban Zone Bill has officially been signed into law by the President of Costa Rica. Passed on March 7, 2014, this bill will allow the current residents living within the restricted area of the maritime zone to remain in possession of their property. Although ownership will remain with the state, it will allow for a concession contract so that the people living within the restricted area can maintain possession through the expiration of the moratorium in September 2014. Although this does not solve the ultimate goal of acquiring official legal title to the land, it will allow for more time to eventually achieve this goal. This is Molly Manson with LO10 News. Back to you.
The breaking news clip you just saw further illustrates the urgency and continuously changing nature of the challenges facing the residents of Talamanca. As recently as March 20th, 2014, the Coastal Urban Zone Bill was signed into law by President Laura Chinchilla. While this bill does not reach the ultimate goal of acquiring permanent title, it establishes a groundwork to begin developing long-term solutions that will allow the residents living within the restricted area of the maritime zone more time to find a viable solution. It is at this juncture that we hope our research will assist in identifying a starting point of legal tools, human rights, and land rights theories that can be used in conjunction with international treaties